sorry, sir. I'm one of. This is a public document. Brought in by the medical council through the prosecution. So they serve us this thing today. And if you watch there in this particular medical report, you can see all the ailments they say that Nnamdi Kanu is suffering from. And surprisingly, somebody that has all these particular issues, you now, in the last paragraph, to say that from your own distance, he can stand trial. Somebody that is passing through all this ailment. Having said that, too, go to make a consequential order. Say, please, go and examine him and report back to me. They never examined Nnamdi Kanu, only for them to come up with this report. Nigerian Medical Council, they should be very careful because this is a professional body and you are expected to act professionally. In your report, you are expected, I'm not a medical doctor, but I'm a practicing lawyer. You are expected to show that on this particular day, we obtained his specimen. We carried out this lab, and the lab showed this, and we are talking about somebody's life, for goodness sake. You cannot just enter into your office room and you open your system and start writing trash. And you want court to rely on it. And surprisingly, we are expected to take a date for us to go. And because when the court gave us an opportunity to respond, we are ought to have taken a date to confer from our clients. It was when Nnamdi Kanu said, what? We are the people that even gave Nnamdi Kanu this thing. When the court was about to sit, we are talking about somebody's life. Of course, as a matter of this thing, the Igbos are on trial. This is a war against the Igbos. Of course, you are here when the president ordered the police and the army to go and negotiate and have a discussion with the terrorists and the non-bandits in this town. And somebody that is exercising his rights as given to him by the constitution, both local and international legislations, and you say that he should enter trial. Trial for what? What is it? What are you trying for? Do you have even jurisdiction? Does the court have jurisdiction to entertain this particular matter? Somebody that has been discharged by court of appeal. So we don't want to go into that. This is a trial. Again, the Igbos are on trial. This is a persecution, not a prosecution. And I stand by it. And I'm calling the entire Nigerians. It's the Igbos and the Nnamdi Kanu today. It can be another person tomorrow. And we should stand against it. That's why we are protesting. Why should we be treating a human being like this? Simply because the offense Nnamdi Kanu committed is because he's an Igbo man. Can you do it somebody from the north? Can you do it somebody from the west? You cannot. People have been agitating. So has been going around agitating for Republic of Oduduwa. Have you arrested him? The answer is no. Because Nnamdi Kanu is an Igbo and they feel that nobody can speak with him for him. And we are saying no to that. We can never be intimidated. Nobody is more Nigerian than anybody. Nobody is a second-class citizen in this country, and we are going to fight it. I'm begging judiciary not allow yourself to be used. They know what they are doing. Are you telling me that it was on the 13th? Court gave you 2 weeks. After 2 weeks, you now produce the document on the 13th, and you kept it with you. You did not allow us to go and see our client with it, only for you to serve us 5 minutes before court is sitting, and you asked us to respond. Is this injustice or injustice, for goodness sake? We should call evil, and when you call evil, it will stop existing. That is our submission. Thank you.
Good evening, everyone. Thanks for joining me in this video. This is Thursday, the 16th day of October 2025. Breaking news: Nnamdi Kanu files preliminary objection against further trial over illegal rendition, repealed law. Now, I understand the stress that the legal team have been undergoing in the course of defending their client, Nnamdi Kanu. I understand everything that they have been through. I know that if you are not in the field, you don't know how difficult it is to play ball. But I am of the opinion that this is what they're supposed to have done since. This is what they ought to have done. Because what this means is that they have to establish the fact that Nnamdi Kanu ought not to stand any trial. Nnamdi Kanu ought not to stand any trial by the issue of illegal rendition. Now, Appeal Court of Nigeria, because of this, discharge and acquit Nnamdi Kanu and says no court in Nigeria have jurisdiction to try Nnamdi Kanu. But because of federal government factor, you understand now, It's like in a community when you have a case against the king of the community, even the chiefs who are to judge the case will compromise because of the fear of the king. That is exactly what is happening to Nigeria. After the appeal court discharged and acquitting Nnamdi Kanu, what happened? The federal government started manipulating so many things, appealing and taking the case from here to here. It doesn't make sense. And I think that the lawyers of Nnamdi Kanu supposed to have, stand on their ground right from the beginning and say, we are not joining any case with Nigerian government. Nnamdi Kanu is not supposed to face any judgment. The judgment he faced before is passed. The court has cleared him that he don't have anything against, like, he's not guilty against any charges filed against him. Then what else are you trying? Now, one of the things that baffles me is that I am not a lawyer, but I read the ruling of a Supreme Court, which states that Nnamdi Kanu never jumped bail. Do you understand? That the military invaded his house, that he ought to run away for his life, and he did, he ran. Now, why is he in DSS detention? Because by the ruling of Supreme Court, his bail has been restored. Why is he there? I am not a lawyer, but I am just asking. So I think that what the legal team supposed to do from the beginning is that they're supposed to tell Federal High Court, we are not joining any issue with this court. We are not coming for any ruling until you obey the Supreme Court. If you refuse, let us go to Court of Appeal. Let us go back to that Supreme Court. Supreme Court says that this man did not jump in. Then why is he in DSS detention? Why is he in DSS custody? So I think what they did is very good, and that is what they're supposed to have done from the beginning, that this man supposed not to be facing trial. You kidnap somebody and you bring the person before the law when you violate the law. It doesn't make sense. It is time for people to put away fear and face the fear. I know it's because of fear. If you listen to all the whole Igbo politicians, they are talking about let's negotiate. Last year, December, they said that the Tinubu is going to give Nnamdi Kanu as a Christmas gift to the Igbos. You say Nnamdi Kanu a cow or a goat that you will say Tinubu will use it to give Igbos Christmas gift? And where is your Christmas gift up to today? You people knows what you are doing now. Apart from that, you see, I had the news this afternoon that the Ohaneze Igbo are saying that they are not involved, governors are not involved, senators are not involved, ministers from the southeast, all of them are not involved in October 20th protest. What is their reason? They said they are negotiating a political solution to free Nnamdi Kanu. These people don't want Nnamdi Kanu to be free. Nnamdi Kanu has been there since this has been their language. How many years does it take them to release a military leader who was accused of treason because he confessed that he's the one sponsoring bandits at the time? Nobody knows. They just release him. They withdraw the case. But you people don't want this man to be free because of his influence. So when I saw the news that the legal team have filed a preliminary objection, I said that is what they're supposed to have done since. Now let us understand the details of the article. This from Sowore Reporters, as you can see. It reads that the detained leader of the indigenous people of Biafra, Bob Nnamdi Kanu, has filed a preliminary objection before the Federal High Court in Abuja, seeking to strike out or permanently stay his ongoing trial on terrorism-related charges. Kanu's legal team urges that the federal government continued prosecution is unconstitutional, citing multiple violations of its fundamental rights, international law, and the jurisdictional competence of the court. In the motion filed pursuant to Section 1, 35, 36, 42, 45, and 46 of the 1999 Constitution as amended, and several international human rights treaties, Kanu seeks a declaration that his prosecution under the Repeal Terrorism Prevention Amendment Act of 2013 is null and void. He contends that the law under which he is being tried was repealed by the Terrorism Prevention and Prohibition Act 2022 and therefore cannot sustain any criminal charge. Kanu also challenges the 2017 proscription of IPOB, describing the order as unconstitutional because it was obtained ex parte without notice of fair hearing, and in disregard of a subsisting ruling by Justice Bintanyako, who had earlier held that IPOB was not an unlawful society. Among the reliefs sought here are a declaration nullifying all charges framed under repeal laws, A declaration that the continued prosecution of the defendant under the Repeal Terrorism Amendment Act 2013 and upon a proscription order obtained ex parte and without fair hearing, which violates section 1, 36, 1 to 12 and 42 of the Constitution and Article 7 and 26 of the African Charter, and is therefore null and void. A declaration that the Federal High Court ex parte order proscribing IPOB obtained without notice or hearing, and why Justice Binta Nyako's subsisting ruling that IPOB is not an unlawful society remain in force, constitutional, unlawful, and cannot be for grand criminal liability. An order striking out or permanently staying count 1 to 8, save count 15 of the amendment charge dated 14 January 2022 for being barred by double jeopardy, having the same factual ingredients as counts 6 to 14 earlier, struck out by the Federal High Court on April 8, 2022. Another declaring that the defendant extraordinary rendition from Kenya without extradition proceedings or due process violated section 36(1) and 9 of the Constitution, the Extradition Act, Cap E25 LFN 2004, and Article 12 and 13 of the African Charter, thereby robbing this honorable court of jurisdiction. Another nullifying all proceedings conducted in breach of the defendant's right to adequate facility for defense, confidential communication with counsel, and fair hearing, particularly the eavesdropping, seizure of legal materials, and denial of unmonitored access, and for such further orders as this honorable court may deem fit to make in the circumstance. Kanu further urges that this continued detention after the Court of Appeal judgment of October 13, 2022, which discharged him of all charges, constitutes contempt of court. Citing the Supreme Court's precedents in Ojukwu versus the military governor of Lagos State, 1986, the defense insists that the government, being in disobedience of a subsisting judgment, cannot validly seek the court's indulgence. So, the article continues its voluminous, but what I'm trying to say here is that what the legal team are doing now is what they're supposed to have done before. In my opinion, you know, if you're not in the field, you don't know how football is difficult. You might even be looking at them, you say, why can't this man pass it to this man? So I'm not a lawyer. So I understand that these people have been going through a lot, and thanks to them. But this was what I was expecting right from the beginning. Honestly, I was expecting this right from the beginning. But anyway, thank God that it is here.